Happy birthday. It's your 40th birthday. Our first meeting was in June of 1972. Now I know each of us is unique in what we do in the courtroom. So I'd like to tell you a little bit about my own career and excuse my laryngitis today. I did all of my practice in Arizona, basically in Tucson, Arizona. And I like to think that my wit was my passport. People use words without really thinking about them, but a passport is a pass that gets you from one country to another. I was born and raised in Europe, and I was taught by my father, number one, dream, no charge for alterations, and two, give good weight. In the years when I grew up, every neighborhood had a butcher, and a butcher was known as to whether or not he gave you good weight or whether he put his thumb on the scale. I was always known as giving good weight. When I started my arguments, I did not start with ladies and gentlemen of the jury, may it please the court, but I would start right off by saying, we are here to do the bitter bookkeeping of death, if it were a death case, or you are here to appraise this very serious injury caused by this corporate defendant. When I started off as the prosecutor, and I set the all-time record in the history of Tucson by losing 14 straight jury trials. So my first case, the judge said, and by the way, I got sworn in on a Saturday and tried my first case on a Tuesday. The judge says, you want a voir dire at the panel. And I turned to the lawyer behind me and said, what's voir dire and what's the panel? I went to law school, but trial procedure was not a required subject. But I learned very quickly as to how to present your case to a jury. In every case, after a couple of years, I told them that a jury grows a communal nose, a large nose that fills the courtroom and smells out the strengths and weaknesses of the case. And certainly my case, my client's case, had weaknesses as well as strengths. The jury is empowered when they take their oath. A jury is America in action. And if you keep it simple, they will get the right result. My job was to present a good piece of pound cake, not to have whipped cream, not to have chocolate sprinkles, not to have a cherry on top, and not to have them feel that someone was handing them a line. When I left the county attorney's office, I had run the campaign of 2 of our 5 judges. When I started, there were 4 judges on the bench, and when I went into private practice, there were 5. And I'd run the campaign of 2 of them, both of whom were far behind. I came in kind of at the last minute, and the campaign for one judge who had unfortunately made some public mistakes, I said, keep Judge Jones on the bench. And for my boss, the county attorney, running for another courtroom, I said, promote Judge Smith. I knew how to use words. I collected words as if they were valuable jewels. And the jury knew that I thought that as a jury, as those 12ers that we started with originally, there was a great amount of wisdom and a great amount of age. A jury is different than each of 12 jurors, and a jury changes during the period of the trial. The jury you start with is not the jury you've got at the end of the trial. Things have happened, things have changed. Before I became a lawyer, I was a disc jockey. I studied radio in high school. There was no TV. I learned to write radio scripts both in high school and in college, and how to act on the radio. I painted with words. I'm 82 years old now, so when I started, we were after the war, after the Depression. I grew up in the Depression, and I knew the value of words. One of the judges whom I helped to elect taught me that the most important people in the courthouse were the staff. That if you intended to be a full-time trial lawyer, it was the staff who distinguished the real trial lawyers from the bullshitters, the people with the thin veneer. After a few years, when I argued behind the rail, many of the courthouse staff and quite often other judges came to hear me sum up. The jury knew that whichever side they ruled for, they were doing a worthwhile job. You must understand that when I started, there was no public defender's office. So on Mondays, you'd get assigned, if you were sitting in front of the rail, 2 or 3 criminal cases to try. And our courthouse was a Spanish territorial courthouse with 5 superior court rooms upstairs and 1 justice at the peace office downstairs. If you did driving under the influence cases, DWI, as I did, you got a jury. But there was no voir dire. The justice of the peace had his bailiff go into the courtyard and collar 6 of the people standing there, usually all men, telling them the case would not last more than 2 hours. That was the time limit. and there was no voir dire. I tried probably 50 of those jury trials, and I soon learned how to relate to the jury and have the jury relate to me. In every case I tried in Superior Court, and I started off as a criminal guy, doing mainly criminal defense. I even represented an insurance company one time and got my head handed to me, and then little by little started to do some personal injury. But I always gave a jury some crisp sentences that wrapped up a bale of thought. They were like bales of cotton, which were all over the area around Tucson. Your fine cotton, your Pima cotton came from Tucson, because Tucson was Pima County and it was the Pima Indians. I rarely explained these crisp sentences. I knew that someone on the jury would understand them and explain them to the other jurors, but I wanted the jury to take something home with them that they would talk about at the dinner table. Most of our jurors were women. The men usually found some excuse not to serve. And I often talked about the unfairness that when women got married, that they took their husband's name. This had nothing to do with the case, but it was just a thought that needed to be brought up. In every case, without exception, I told the jury that each one of them, without exception, had to stand up at least once in the jury room and express their opinion. Jurors are all equal, no matter what sex, no matter what they did for a living, whether they were a janitor, a doctor, a lawyer, a businessman. In the jury room, they were all equal. I talked to them about reasonable does not mean cheap. And the jury saw how the staff in the courtroom related to me and how they treated me. Unlike any other lawyer, I made it my business to know the name of the bailiff, the name of the secretary, the name of the clerk, and the name of the court reporter. And when I addressed the jury, ladies and gentlemen, and I addressed His Honor, I addressed Mr. So-and-so, the bailiff, Mr. So-and-so, the court reporter, Madam So-and-so, the clerk, and Madam So-and-so, the secretary. The people at the courthouse respected me, and the chief clerk of the courthouse, who was elected and used to be the mayor, was my biggest fan for about 20-odd years. Every single case I argued, he came up and got most of the staff to come up with him. I talked to the jury about dead yesterday and unborn tomorrow, and how important today was. I talked to the jury about how my client had lost their privacy, their modesty, when they were paralyzed. I explained to the jurors that even in the men's room, there were modesty panels between the urinals. And what did it mean to my client to have someone put their finger in my client's rectum to remove their feces? That's all they needed to hear about a spinal cord injury to understand how important it was. I felt I did not win cases. The other side lost them. And by showing that the number the other side gave them was just cheap, I multiplied it and divided it by the number of days and 16 hours a day, and showed that they wanted to give a dismal number to my client. And in rebuttal, and I wore this jacket every day in court, I acted like a professional. And I said, don't put your stamp of approval on that kind of a number. And I would take my jacket off in rebuttal, crumple it up, throw it in a chair and say, if you put your stamp of approval on their number, I would rather you give us nothing. And at the end of the case, the judge would always say, Grand, somebody is going to give them nothing and you're going to get sued. You know, I felt I was always a surgeon and always a teacher. I slit open the cavity and taught the jury about anatomy. I was very lucky. At 3 years in private practice, the Medical Society of Pima County one night fired the largest firm in town and hired me as sole practitioner to represent the Medical Society, and I did that for over a decade. No medical malpractice cases. $600 a year is what I was paid, and I had to attend a minimum of 3 meetings a month and be available to every doctor 24/7 who didn't want to bother his own lawyer. But every doctor almost in town, when one of his patients was injured, recommended that they come to me, and that's how my practice got built. It was not a referral practice, it never was. It was individual people coming to me. I attended open heart surgeries, orthopedic surgeries, the birth of the child. I attended over 10 autopsies, just the pathologist and I. And when 2 of the young orthopedists were studying for their boards, for a number of months, I went with them 3 nights a week to read the anatomy book to them out loud while they did a minute dissection. I was an expert in anatomy. I taught anatomy to the jury so they knew it. And I taught the jury about life. What I did is not something you may have done in your community. I never worked for anybody else. I never had a partner. I marched to my own drumbeat. This is an interesting time. At this meeting, you will have a memorial for 6 of our members, 6 men who died. I spoke to all 66. I saw face to face and knew 65 of them. but one of our first members had an inoperable brain tumor. He was from California. He wanted to become a member, but he could not attend a meeting. It's amazing. I hope someday, and I set the limit of 50 members, everybody had to have tried 50 personal injury cases to a conclusion. I certainly never heard of second chair, and everyone had to have at least $1 million verdict in damages not being punitive. I got the first $1 million verdict. In fact, it was $1 million plus in 1971, collected in full in auto collision. And in 1972, in a rear-end collision between two civilian automobiles, I got a $3.5 million injury verdict for my client and a $400,000 verdict for the passenger in the car. By a stroke of luck, the person causing the rear-end collision had a $5 million policy, and that was collected in full. But people ask, what was your favorite case? What really showed your skill? It wasn't either of those two verdicts. It was a murder one verdict. And in those days, the jury decided first-degree murder, life or death, decided that right away. Second-degree manslaughter or not guilty. My client admitted shooting her husband while he was asleep. She admitted it on the witness stand. The jury was told there was no defense of self-defense. He didn't strike her. There was no defense of insanity, irresistible impulse, or diminished responsibility. Besides which, my client instructed me strictly that I could not ask the jury for first-degree life. I couldn't ask for second degree. I couldn't ask for manslaughter. I got a not guilty verdict, and that called for a real lawyering. The inner circle really has not changed in 40 years. I started it to be a brain trust. I really started it hoping at that first meeting someone would tell me how I could keep the largest verdict in the history of the United States. I was really scared. Fortunately, the insurance company was so arrogant, they never made an offer after trial of any substantial money. The circle is a brain trust. The beauty is you see the same people every year. You form friendships. There are incredible hospitality between the members. There are disagreements. One member and I early on had a disagreement about a fee that he owed me, and although we had agreed on a certain percentage, when it came to distribution, he deducted $83,000. So when we had our next meeting, which was in Sun Valley, I asked him about that. He said, well, I just want to pay less. And I said, that isn't fair. He said, I'll flip you for it. I said, okay. He flipped. I called. I won. And he paid the other $83,000. So all I can tell you is it's been a wonderful career. It's been a wonderful organization. And I hope you keep it the way it is. It is unique. It's different from any other organization. It is what the French call a club privé. It's a private club. It's not someone who gets in because somebody lobbies for them. We don't allow that. Nobody can lobby for an office. As to the 66 men who died, and as to the 6 we remember in this meeting, keep in mind that each of us will die. We will each end up in the back of the book. And as some poet said, a life so rich is hard to leave. What we try to do is when someone passes is to drink a toast to them and remember, no matter how important we are, we too will lay beneath the earth. A wild horse can stamp over our head, but cannot break our sleep. So when we pass on, the rest of us need to make a toast and turn down an empty glass. Thank you.